So good afternoon, everyone. According to my clock, it's just turned straight up noon. I wanted to welcome everyone to the Advanced Health Plans Trust 2020 Legal Update webinar. I know that this is over the lunch hour and everybody's time is precious, especially during fourth quarter, but we felt like it was important to have a dedicated webinar to this legal update. We normally do this during the Advanced Health Plans user group meeting, but as you all know, especially those that attend regularly, know that meeting can get pretty long, especially with the legal update, so we separated it out. You know, the world of healthcare it is ever changing, and we're going to kind of walk you through some of the important information and reminders for all Advanced Health Plans member banks. So with that being said, I'd like to introduce actually our speaker and trust counsel, Cori Cook, which as of last week became Cori Zavada. Had a beautiful wedding on a sandy beach somewhere. So Cori, congratulations.
Thank you.
Our relationship with Cori, as far as the trust counsel is it's been going on for just I think a little over a year. Cori has really kind of done a top to bottom review of the plans and is making a few changes that I think are really good, and she's going to kind of walk us through all of those things. So I think everybody can just settle back. Hopefully you've got some a warm drink, coffee or tea or something, and maybe even a snack for lunch, and sit back and enjoy the webinar. So Cori, take it away.
Thank you so much, Jay, for the introduction, and thank you for allowing me to be here with you today. I'm sorry that my camera is not working. But when I look at this picture that Jay has up on the screen of me, I almost don't recognize myself. This was obviously pre-COVID. My hair's twice that length because of COVID and the inability to get to a hair salon, and I now have a new last name. So if you were to see me and see my last name, please be assured I'm the same person. It's just, you know, COVID's done a lot to all of us. I wanted to give you a little bit of information about my background, just so you have a better understanding of who I am. I've been in the self-funded industry for over 20 years. I've actually known Jay Kempton for many of those years, just from an industry involvement standpoint. In my prior life, I was the Chief Operating Officer and General Counsel of a different TPA in the US that worked nationally. I started my own company, it will be actually 9 years ago on November 1st. So I'm coming up on an anniversary here. I set out to just help self-funded health plans directly, as opposed to in the TPA world. The honest answer is that my only child was getting ready to go into high school, and I needed to start my own business so that when she went off to college, I had the ability to follow her. And so that was 9 years ago here next week. I have the AHPT Trust is a MIWA, as you all know, a multiple employer welfare arrangement. I have MIWA clients across the country that I provide services to. I have lawyers and dentists and bankers and credit unions, and I think that might be all of them right now. I've been working as your trust counsel for a little over a year, and I can't say enough about the work that goes on behalf of this trust and the folks at Kempton. It is it's far and above what I see other TPAs doing across the country. So please know that you are in good hands. I kind of wanted to start the legal update on a national level, and then I'll kind of move into some trust specific matters. The first national legal update I want to provide to you surrounds the Bostock decision. This was a decision from the Supreme Court of the United States. On June 15th, the U.S. Supreme Court issued a landmark opinion in Bostock versus Clayton County, Georgia. Among other things, this decision incorporated an individual's sexual orientation or gender identity status into the definition of sex under Title VII of the Civil Rights Act of 1964, which makes it unlawful for an employer to fail or refuse to hire or discharge an individual or otherwise discriminate against any individual with respect to his or her compensation, terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin. I know that's a mouthful, and I'll kind of explain some of the finer details. This Bostock ruling took effect immediately upon its holding on June 15th of 2020. While this decision largely revolved around employment, the hiring and firing and the treatment of your employees, it does have implications on employee benefit plans. In dicta, the Supreme Court holding discussed other areas of discrimination, including fringe benefits. Applicable regulations define fringe benefits as medical, hospital, accident, life insurance and retirement plans, profit sharing, bonus plan, leave, other terms and conditions and privileges of employment. So this isn't a benefit plan per se. It is an employment decision that extends its tentacles into employee benefits. Now that the term sex includes sexual orientation and gender identity, health plans must ensure that their plan provisions do not discriminate against individuals on the basis of sex. Areas where a plan could see challenges include exclusions for gender dysphoria, sex reassignment surgery, hormone therapy treatment related to gender identity, or family planning benefits for LGBTQ employees. This is not to say that all health plans must cover all of these conditions and treatments. However, a plan opens themselves up to challenges if they cover something and then categorically exclude a certain treatment based on an individual's sexual orientation or gender identity. For example, most plans cover hysterectomies for women due to fibroids, endometriosis, cancer, among other things. Therefore, since the plan covers hysterectomies, it may be unlawful for a plan to deny a hysterectomy for a transgender man, an individual that was born atomically a female, who wishes to have a medically necessary hysterectomy due to gender dysphoria. Similarly, if a plan covers hormone replacement therapy to treat breast or prostate cancer, denying hormone therapy to treat gender dysphoria may result in a violation of Title VII of this Supreme Court decision. There are other regulations that are impacted by this decision, including the Mental Health Parity Act and the ACA. The parity regulations do not mandate coverage for all mental health and substance abuse conditions. However, they require that any limitations placed on mental health substance abuse benefits be in parity with the limitations placed on medical and surgical benefits. So, for example, a medical management standard or benefit limitation cannot be more stringent for mental health conditions than they are for other covered conditions. A simple example, if you have a $20 copay for an office visit, you cannot have a $50 copay for a mental health office visit. Likewise, the ACA preventative services mandate is implicated by this Bostock decision. There are gender-specific preventative services that are covered at 100% without cost sharing right now. An example would be mammograms after a certain age and prostate screenings after a certain age, and this all came about due to the ACA. These preventative services cannot be limited by an individual's sex assignment at birth. So, for example, a plan could face a challenge by denying a transgender woman, meaning born atomically a male, request for a mammogram simply because they were born male. However, the mammogram will still need to be medically necessary and fit under the criteria outlined in the ACA. Another example that kind of is easier to resonate for some people is if you cover fertility, then you can't discriminate based on sex. And if you allow IVF for heterosexual couples, you would now likely be required to cover IVF for a male-male or female-female couple. So as you can see, the decision on its face seems somewhat easy to comprehend, and the more we get into it, the more complicated it gets. Back to the fertility example, again, this law does not require that we cover everything. So if we didn't cover fertility, we'd be fine. But once you cover certain things, then we cannot discriminate unintentionally or intentionally. Finally, if a plan participant is in a PPO network, the plan must ensure that the PPO network allows for equal access to care. For example, participation in the PPO network they have to have physicians who specialize in gender dysphoria. Otherwise, that could result in a violation of Title VII and this decision. This has its own set of challenges, as you can imagine, because a plan sponsor or a plan, we have no control over who's in or out of the network. We kind of relinquish that control to the PPO network. But nonetheless, this is kind of on our radar. Some self-funded health plans have already been mindful of these particular exclusions, because for several years, if a plan was subject to Section 1557, they already had to be offering and not discriminating in this manner. This Supreme Court decision now just extends this rationale to all plans, and thus employer-sponsored plans, regardless if they're subject to 1557. There's much discussion among legal scholars on the true impact and the far-reaching implications that this decision has. At this point, we have amended the AHPT plans very conservatively to allow us to kind of flex as this issue plays out. I personally see it playing out somewhat like gastric bypass did several years ago. And the medical community kind of needs to take the lead on creating criteria. And from a plan perspective, the coverage questions will all fall to medical necessity. But it's definitely something that could be challenging at first until we kind of find our way. Somewhat of a big issue, just wanted you to be aware of it. You know, not only does it impact you as an employer on many levels, it now impacts the benefits that you're offering. Another national decision that I'll just touch on is the Little Sisters of the Poor. This was a SCOTUS decision as well, the Supreme Court of the United States. This was likely one of Ginsburg's last dissenting opinions. On July 8th, the United States Supreme Court upheld 2 Trump-era rules expanding religious and moral exemptions to the ACA contraceptive mandate. This issue started in 2014 with the Hobby Lobby case, where Hobby Lobby challenged the ACA contraceptive mandate, claiming that they were a religious organization and that it violated their religious and moral beliefs to force them to pay for contraceptives. This recent case, the Little Sisters of the Poor versus Pennsylvania, held that the government had the authority under the ACA to adopt broad religious and moral exemptions to the contraceptive mandate, and the rules did not violate the Administrative Procedures Act. So this ruling in this case kind of confirms 2 things for us. Number one, employers that object to the coverage of contraceptives for religious or moral reasons can decline contraceptives for employees or students. And number 2, the accommodation process, which enables employees and students from objecting to employers for accessing that, is optional. The final rules, which were upheld in this decision, expand the exemption that previously applied only to churches and similar religious organizations. Now the religious exemption is available to non-government nonprofits, for-profits, education institutions, insurers, and individuals who have a sincerely held religious objection to the provision of all of the subsets of contraceptives. So there's sterilization, and there's many things that fall under that contraceptive umbrella. And there is a similar moral exemption in the final rules, which allows these same entities, you know, non-government employers, nonprofits, privately held for-profit insurers, education institutions, to assert an exemption of the contraceptive mandate based on a sincerely held moral conviction. Under both rules, if an employer objects to the contraceptive mandate on religious or moral grounds, a group health plan and the coverage itself is exempt from the HSRA guidelines, which that's where we get the preventative guidelines from under the ACA. Altogether, there is no self-certification required or notice to the government at this time. ERISA, however, requires employers to document covered services in their SBCs, their Summary of Benefits and Coverage. And exempt employers taking advantage of the exemption will need to update those documents if they're no longer being covered. This does not directly impact the AHPT and the plans that are currently being offered, but wanted you to kind of be aware of the changes in the healthcare landscape in 2020. Which brings us to our next one, which is healthcare and the election. Access to affordable healthcare remains a high priority for voters in this election. Both candidates have managed to ensure that healthcare coverage, sometimes it's referred to cost, I see them as two totally separate issues, among their top domestic priorities. However, as you know, their approaches differ. Biden favors maintaining and expanding coverage under the ACA and would keep the employer mandate in place. He also supports a public option similar to Medicare. He also supports lowering the Medicare eligible age to 60. And I would argue that Biden and his administration, if elected, would be proponents of a Medicare for all approach. Trump opposes the ACA and is supporting another Supreme Court challenge that is currently on the docket as to the constitutionality of the ACA. Trump's plan to date has focused on allowing employers to use various health reimbursement arrangements to reimburse employees who want to buy coverage on the exchange. He has promoted regulatory efforts to require hospitals and healthcare providers to be transparent about their pricing. We still have a long way to go when it comes to transparency in healthcare, but at least it's on his radar. He has signed into law legislation banning gag clauses, which prevented pharmacists from telling customers about less expensive drug options. And he has helped to expand the reach of telemedicine services. Both candidates support ending surprise billing by out-of-network providers. Currently, this is only a state legislation issue and has not been addressed yet at the federal level. Challenges to the ACA. I mentioned that Trump is opposed to the ACA and is supporting a Supreme Court decision. On November 10th of this year, the Supreme Court will hear oral arguments on whether the ACA is constitutional or not. The court is expected to rule on the matter before its term ends on June of 2021. A vacancy of the Supreme Court was created by Ruth Bader Ginsburg's death in September. It's my understanding, although I haven't watched the news in the last 24 hours, I believe Amy Coney Barrett was confirmed this week. In the meantime, the healthcare law remains in full effect during the litigation, including all employer coverage obligations and reporting requirements. The case that made its way to the Supreme Court has a complex and complicated procedural history. I won't bore you with the details, but suffice it to say there's a number of possible outcomes that we could see. Number one, we could see the case being dismissed on technical grounds, leaving the statute in place. The court could decide, for instance, that Texas and the individual plaintiffs lack standing to bring the lawsuit in the first place. We could see the ACA being affirmatively upheld. We could see them upholding the statute while finding that the individual mandate to be void without its penalty, essentially maintaining the status quo that we have right now. We could uphold the statute but void the individual mandate and other provisions closely linked to the mandate. So that could be a little bit of a mixed bag. And they could strike down the law in full, although this option has been viewed as unlikely by legal analysts. Should it happen, however, the effect of the ruling would likely be delayed giving Congress the opportunity to correct any of the unconstitutional defects so that it could pass a replacement health care bill. We're currently watching this case carefully and analyzing the responses and the potential outcomes, because it could impact many things at the employer and the employee benefits level. The other item at the national level is obviously COVID, right? Then we had COVID, and along with the many challenges, both personal and professional, we got the CARES Act, which created a number of expansions, right? It had the Paycheck Protection Program, which you guys could probably do a week's worth of webinars just on that. Student loans, unemployment insurance, deferred Social Security tax payments, employee retention tax credits. However, specific to group health plans, the CARES Act did a few things. It expanded the use of HSAs. The CARES Act allows high deductible health plans that are paired with HSAs to cover telemedicine costs of the cost sharing until the end of this year. So prior to the CARES Act, you could not have free telemedicine services under a high deductible health plan that's paired with an HSA because it would violate the first dollar rule. This piece of the CARES Act gives us a little bit of a break during the rest of 2021, since it was brought into law, where we can forego that first dollar issue and allow for folks to get zero cost sharing for telemedicine services if they're in a high deductible health plan. A new safe harbor permits the high deductibles to cover telemedicine and other remote care services before they have to meet that deductible. Normal cost sharing can still be imposed for telehealth visits, such as through copays that the plan may require after the deductible is paid. These provisions are temporary and will sunset on the 31st of December unless Congress extends them and makes them permanent. I'm personally hoping that they do, but that is yet to be seen. The COVID-19 testing without cost sharing was another thing that came out of the CARES Act. It extends coronavirus testing covered without cost sharing and outside the deductible by fully insured and self-funded plans as required by the Families First Coronavirus Response Act. I refer to that as FCRA. To any services or items provided during a medical visit that results in coronavirus testing, including an in-person or telehealth visit to a doctor office, urgent care, or emergency room. This coverage requirement remains in effect only while there is a declared public health emergency under federal law. And again, we don't know when that is going to be lifted. FCRA, the Families First Coronavirus Response Act, as you know, created also the paid sick leave and the emergency FMLA that we as employers have been managing over the last several months from a staffing perspective. The other item at the national level, just to kind of make sure everybody knows what's going on out there, on June 10th, the IRS published a proposed rule that would let employer-funded health reimbursement arrangements and HSAs pay for employees' care received through direct primary care arrangements and health care sharing ministries. Both options have attracted interest as lower cost alternatives to traditional employer provided group health plans and to non-group health coverage purchased through an ACA marketplace exchange. The direct primary care arrangements are typically a contract between an individual and a primary care doctor, under which the doctor agrees to provide medical care for a fixed fee. Usually it's paid monthly, sometimes annually. And a healthcare sharing ministry are tax-exempt organizations under which members share a common set of ethical or religious beliefs and share medical expenses amongst themselves. HRAs, and we're starting to expand in our vocabulary on what is available to us from an HRA perspective. Back in the day, all we had were HRAs, health reimbursement accounts. We now have qualified small employer HRAs, also known as QSE HRAs, And these are HRAs that are integrated with traditional employer group health plans, and we have individual coverage HRAs known as ICHRAs or ICHRAs, ICHRAs, and they may require, they may reimburse employee expenses for medical care. Employees have only been allowed to use QSE HRAs and ICHRAs to pay premiums for health coverage purchased on the individual market or through the exchange. This proposed rule would allow HRAs and HSAs to pay for and reimburse these direct primary care arrangements that we are seeing kind of pop up across the country. Right now, this is still in a proposed rule status, and we are waiting for final rules to see how they may be tweaked. There was an opportunity for Q&A, and I have no indication as to when the final rules may be handed down, but we're kind of waiting for those. And could be a great opportunity to make some changes at the plan level or at the employer level as well. At the industry level, kind of moving a little bit away from national, but not too far. When I look at things that are happening at the industry level, the first one that kind of pops up into my head is marijuana. It's always a topic. Marijuana legalization is on the ballot in 5 states for this election. Currently, 33 states allow marijuana for medical use, and 11 of those states and DC allow marijuana for recreational use. With the majority of the states already having legalized cannabis and 5 more states voting on it this November, it's increasingly important for employers and plans to consider their stance on marijuana for future discussions. When I look at the 4 states that kind of the AHPT is in, Oklahoma, medical marijuana is legal. Louisiana, medical marijuana is legal. Texas, it's not. And in New Mexico, it is. However, we still have this overarching law, federal law, continues to classify marijuana as a Schedule I narcotic, according to the DEA. This means that it's not FDA approved, and therefore health plans are not required to cover it. In fact, most health plans have a provision in their exclusions that say it will not pay for items that are not FDA approved. It's my opinion that Big Pharma will likely prevent FDA approval of this for some time. And for those cases where there is therapeutic value, patients will continue to have to foot the bill for those. Also on an industry as well as a national level, telemedicine is a big topic lately as a result of COVID. If COVID's helped certain things, telemedicine is one of them. COVID-19 has changed many things, and amongst those is our willingness to try, and in some instances be forced to utilize telehealth services. The IRS announced relaxed restrictions due to COVID-19 that previously hindered telemedicine services, including high deductible health plans from offering telemedicine visits without violating the first dollar coverage. So under high deductible health plans, we previously had to have a copay. Excuse me, I'm gonna take a drink. We previously had to have a copay so that we didn't violate the first dollar coverage rules. During this flex period of COVID through the end of this year for this purpose, those rules are somewhat laxed. And then the FCRA requires including the cost of telemedicine visits without cost sharing. So that's been a benefit on the telemedicine side as well. As a result of the pandemic, telehealth services experienced exponential growth, as you can imagine. However, its success depends largely on the type of workforce involved. So, you know, some employers and employees don't have easy access to technology and aren't comfortable using it, and you know, haven't seen the impact of telemedicine that others have. I think this is going to be a growing issue and expansion into the medical field. The other thing that has happened during COVID as a result of telemedicine, as is that they have relaxed the licensing laws of some docs. So pre-COVID, telemedicine doctors had state licensure restrictions. Right now, they are somewhat relaxed for COVID purposes, and I'm hopeful that that maintains after I can't say COVID's gone because I don't think that's a possibility, but from a regulatory standpoint, I hope we move in that direction. Now I'm going to move into compliance and plan changes that have been looked at and addressed over the last year. We have been reviewing the plan documents and the supporting documentation, such as the due diligence checklist and the plan adoption agreement. But before I dive into all of that, Jay, do you have any questions? Want me to highlight anything?
No, Cori, that was actually very thorough. There's a lot of things to think about there, and lots of movement in the healthcare regulatory area. It's interesting how an emergency can actually force some out of the box thinking, especially from the regulator. So anyway, that was a good update. I got a lot out of that.
Oh, good. Thank you. Okay, so in prior years, you folks have had access to a due diligence checklist, and it was posted for you to review. The due diligence checklist is a list of federally required action or notices or compliance or distribution matters, and kind of indicated which party was responsible for performing that function. It's maintained by Kempton and is available on the portal. And I'm going to talk about a few items. I'm not going to go through it in its entirety, but I want to talk about a few things. And then just to remind you, it's not available yet. I still have a few tweaks to make, but when it is available, you will receive notice, and then it will go on the portal. And I would encourage you to go review it. And if you have any questions, please pose them so that we make sure everybody understands what the purpose of this document is and the elements within it.
Cori, I might interject just real quick and just talk to the membership that, yeah, the due diligence checklist has been something that has been requested and really to be kind of that one-stop place where a bank or an HR officer can go out, look at that document, and see everything that they need to be. If they ended up having an auditor, or if the board was to come to them and say, hey, have you done your due diligence on our relationship with the Advanced Health Plans Trust? Are they touching all of the compliance points that we need to be thinking about? It would be a document which the bank could go to and say, okay, this and this are the bank's responsibility, while these items over here are Advanced Health Plan's responsibility, and I can see who's doing what and what things I need to worry about and what things I don't need to worry about. So again, that's been kind of fractured through historically, and this checklist has really just been something that's been in development and slated for improvement, but it was definitely driven by the member banks. I think it's a great idea.
Thanks for that, Jay. Like I said, I'm not going to go through the whole thing, but I just want to touch on a few things. A, to give you a flavor what's in here, and B, to kind of point to a few things that kind of fall to that employer umbrella. So the first couple, the Advantage Health Plans Trust fiduciary liability policy, that's something that the trust has to have, and that's obviously something that is taken care of by the trust. Likewise, there is a federal requirement that they have a fidelity bond, and again, that is taken care of at the trust level. On an annual basis, the trust has to file Form M1. It's an annual report that must be filed with the Department of Labor by every multiple employer welfare arrangement operating in the United States. They're typically due at the end of January, and you will see in the checklist that it says that the trust is taking care of this for you, or a contracted vendor. As trust counsel, this is something that we perform on your behalf. Again, annual MEWA state licensure filings. This is something that has to be done every year in all the states in which the trust operates. The person that is doing that, it's the responsibility of the trust, and it is being taken care of by us on your behalf. The AHPT must report member and beneficiary information to CMS on a quarterly basis. This is called Medicare secondary payer reporting. This is managed by AHPT, but the plan administrator is the one that performs this function for you. Here's one that falls kind of in your court. So the 1094 and 1095 reporting. As you know, employers that are considered applicable large employers that are offering coverage have to file 1094 and 1095 reporting on an annual basis. It's an employer function, even though I know that many of you have this performed by somebody else. You will see that this falls under your umbrella or a contracted vendor to do that on your behalf. Summary, when we get to documents like the summary annual report and the SPD and the plan document and the SBC, those all fall to the plan administrator. I'm going to talk a little bit more about those further in my discussion on distribution. Another example that needs to be on your radar, you will see the medical child support order. AHPT must provide notice regarding receipt and qualification of medical child support orders directing plans to provide coverage to non-custodial children. Some states call these different things, but essentially, you know, when individuals get divorced and one parent is being required to cover the children on their health plan, this comes through in the form of an order, whether it's a medical child support order or by whatever name. This information can typically land at the employer level, and then you would have to make sure you communicate that to the plan administrator to get the folks properly enrolled. Let me see what else we have here. There are many notices within a plan that are federally required notices. Just to kind of name a few, we have CHIPRA, Notices of Special Enrollment Rights, WICRA, which is the Women's Health and Cancer Right Act, Newborns and Mothers Health Protection Act of '96, the initial COBRA notices. There's a laundry list of notices that you will see in the checklist. They all say that the plan administrator is doing them. The reality is I have built all of these notices into your plan document and your SPD to satisfy the required disclosures. There's one other one that you will see on the checklist, and it says wellness programs. For plans that are offering a wellness program, certain regulations and notice requirements may be applicable. This falls under the employer responsibility, and I'm going to talk about this in a couple manners. If you are offering what you consider to be a wellness program to your employees that is outside of the AHPT benefit offerings, we probably need to discuss it, because one thing that is important for employers to always kind of keep in the back of their heads is if you're spending employer funds for the benefit of health related to my employees, that equals a health plan. So if you have created a little wellness program that you're operating outside of AHPT, and it's an in-house thing, and it's, you know, and it's fun, and it's, you know, it's a weight loss thing, and it's a this and it's a that, we should probably have a discussion to see if you have any requirements from a regulatory standpoint, because I don't want you to accidentally, unintentionally create an ERISA plan in-house that's not integrated with AHPT and that you may be creating some unintentional exposure on. So when you see that on the checklist, you'll remember that I just said that, and you know, feel free to reach out to me so that I can just help you ensure that you're not heading in that direction. We had several plan amendments and some other changes that needed to be incorporated into the plan. So we are just wrapping up a full restatement for 2021. I can't even count how many plans that we have off the top of my head, but there's a lot. They will all be restated for the 2021 plan year. The last restatement that you folks did was in 2018. There's obviously been a number of amendments since then, and a complete compliance review when I came on board as the trust counsel. I want to highlight a couple of the plan changes. There's been many that we have made that are, you won't notice. They could be very minor, but from a technical standpoint, legally speaking, it was important for us to change them. But I kind of pulled out 4 that are important for you to kind of keep in your mind. The plan historically had an eligibility threshold of 32 hours for full-time employees. And when the ACA came about and the 1094 and 1095 reporting came about and the 4980H rules came about, the government said to us, 30 hours is full-time. And so we made that change to the plan, and anybody that is working or scheduled to work at least 30 hours is going to be considered a full-time employee. We wanted that to be in line with the ACA. We didn't want to create any potential exposure for employers under the 4980H rules, and so that change has been made. Another change that has been made is a change as it relates to the Medicare secondary payer rules. So Medicare has a volume of laws called Medicare secondary payer, and they apply to individuals that are Medicare eligible, and they dictate which plan pays primary and which plan pays secondary. Under a MEWA, there in the past has been an opportunity to obtain what I will refer to as a small employer exception. And so we could look at each individual bank, and if they fit under the small employer exception, we could reach out to the government and get approval, and we could go through all these hoops. A decision was made by the trustees to modify the language in the plan for Medicare secondary payer purposes, and with the exception of a few circumstances that are condition specific, the AHPT plan will always be primary for active employees. So we're not going to look at the individual employer level and their size to make that determination. Another thing that was made and changed in the plan is there was some kind of legacy language in there that talked about an orientation period and how it applied to your waiting period. And after kind of some investigation on my end and some probing questions, I felt that 2 things. Number one, that we may have orientation period language when in fact at some locations we don't have a true orientation taking place. So that was problematic. And the other thing was, at times, if we did or we didn't have an orientation period, when you added those days onto the waiting period days, it bumped us beyond our allowed 90 days per the ACA. So under the ACA, you cannot have a waiting period that exceeds 90 days. So to avoid that potential from happening, we have modified that provision in the plan as well. Under no circumstances will a waiting period exceed. This is something I believe that you guys get to elect in your plan adoption agreement. And for the most part, employers are electing 60 days, and then they would be eligible the first of the month following. One other plan change, it's not specific in the plan document. I wanted it to be somewhat vague, but something that's important for you to know about is if you are an applicable large employer, you have more than 50 full-time employees when you add up your FTEs and your part-timers, and you rehire someone within a 13-week window, there are laws as to whether or not we can treat them as a new hire. That obviously is something that would be a case-by-case basis that you may have questions on if you ever are in that situation. But as a reminder and a little red flag in your head, kind of use the 13-week rule. If somebody is terminated for whatever reason and comes back under your employment W-2 umbrella within a 13-week time frame, we have to treat them differently from a new hire perspective. As for the plan adoption agreement that you have executed in the past, we have broken this into two separate documents. We now have the plan adoption agreement and the subscription agreement. The employer obligations are primarily in the subscription agreement. It reads more like a legal contract, if you will, which will require an execution, and then you don't have to execute it again unless any amendments are made. And then your annual elections and your benefit selections that you make on an annual basis, that is done through the plan adoption agreement, and that's something that's done on an annual basis. I want to highlight a couple of things in the subscription agreement for you. The plan adoption agreement won't look entirely different. I mean, the formatting and maybe it's a little easier to read, and you know, we've kind of rearranged things a little bit, but the purpose is the same. The subscription agreement, which is the document that you will sign once and not again until an amendment is made, if ever, just kind of sets forth a few things. And you know, I encourage you to read it in its entirety when you receive it. But basically, you as the participating employer are agreeing to participate in the trust, and you're agreeing to be bound by the terms of the trust agreement, and that you're acknowledging and agreeing that the trustees in their sole discretion have the ability to select and manage this plan as they have been doing. There is this, I think this is a slight change. I'll let Jay clarify, but there is a provision that I have added in there from a payment standpoint. You know, we would like to get everybody to the point of paying through ACH when you're paying your premiums to the trust. There is a provision in there that talks about, you know, we want to have at least 75% of your eligible employees enrolled. We want to make sure that we keep a healthy trust by having as many people in it as we can. Maybe one or two, an important point that I want to stress here is there's a provision in there that talks about complete and accurate census. So it's your responsibility to ensure that you are providing the trust with complete and accurate census information of eligible employees and any additional information that might be needed. And failing to do so, and failing to update on changes, and if somebody's terminated and they should be offered COBRA and they got married or divorced or they added babies or things like that, could have significant consequences at the employer level. As you know, we have a trust, and then we have stop loss coverage, and so we always, for large claims, we always have a stop loss carrier kind of looking over our shoulder. And I'm going to share with you kind of a horror story as it relates to this issue, just so that it will resonate with you. I had a large dental MIWA, dentists all across a given state that participated in a MIWA for eligibility purposes. And I get a call one day, and you know, everybody's freaking out. They don't know what to do. We have this one individual who works for a very small dental office. I think there were like 4 employees at this dental office that were on the plan. One individual had cancer. The employer, with all the best of intentions, kept them as an active employee and let them stay on the plan for over 2 years. So they were not satisfying the eligibility criteria. They were not paying premiums. They were, I think that the employer may have been paying the premiums for them, I'm not sure, but they certainly didn't satisfy the eligibility criteria of the plan. Well, being that she was a cancer patient, she racked up significant claims for her treatment. And when the trust, the MIWA, submitted a reimbursement request to the stop loss carrier for a significant amount of money, it was in excess of $400,000, the stop loss carrier's first question was, please provide us with the documentation that substantiates how this individual maintained eligibility for this long on the plan. And the employer was like, well, they were on FMLA and then we just kept them on. That's not permissible under the terms of any plan. And so the eligibility criteria and any leaves of absence and any FMLA, those things are very specific and need to be adhered to. And so on your end at the employer level, it's very important to make sure you're on top of that so that only the people receiving benefits are the people that are eligible, because I would hate for you to have to deal with that, much like this dental office did.
Yeah, Cori, let me jump in there real quick. Yeah, so that that horror story is obviously one of your other MEWA clients. I think you said a dental MEWA, not related to advanced health plans, but yeah, I think in the past we've had legal updates. Back when Maria Robles Myers was here, was the trust counsel. We would do that on some of our myth versus fact webinars, if anybody remembers those. And so that has certainly happened on advanced health plans periodically in the past. I'm knocking on wood here. It never resulted in a stop loss claim gap, but it could have. And so I think in the past we've always kind of captioned that as it's the kind of the benevolent employer situation in which the participant would fall out of eligibility, but the bank was trying to take care of the employee, so they would just leave them on, not knowing that they were creating a big gap. And the trust has lots of different eligibility buckets or categories besides active. One of them is COBRA, and if the bank is feeling very benevolent, there's no reason why the bank, if somebody is not actively at work and is no longer eligible, there's no reason why that participant can't elect COBRA, and then the bank actually pay their COBRA premium. That's always available to them. So I just wanted to add that even though your horror story that resulted in a big stop loss claim with a gap there in coverage was not advanced health plans, it is something that we've dealt with and we've struggled with as bankers in the past, and it's always under the best intentions, but it is a risk, and that's a great point, Cori. I just want to give a little bit of context.
Thank you. Kind of the only other provision in the subscription agreement that I'll point out, and again, you'll be receiving this, and feel free to ask questions if you have them when you do. I'm going to point out that there is a 30-day termination provision. So if you as an employer decide at some point you don't want to participate in the trust, the more notice the better, because it impacts all of your employees and dependents that are on the plan. There are laws that also pertain to when you can pull people out of plans, and if they're flexing their premiums through cafeteria plans, and a whole myriad of issues. So more is better. But in here we specifically state that upon 30 days prior written notice is required. I'm probably a proponent of making that higher, but I know that there's a long-standing relationship amongst all the employers in this group, and so far I don't think it's been an issue. I will just point out that there are times when banks go through acquisitions, whether you're acquiring or being acquired, and whether it's an asset purchase or a stock purchase has a significant impact on the benefits and what happens to these people, and whether there's COBRA, and whether they just get dropped off and they have nothing available to them. So in the event you head down that path, it's best to make sure that you're talking to your advisors about the benefits so that you can appropriately address them in your legal documents, and everybody's kind of on the same page on a go-forward basis. Another thing, and this is kind of the last one I'll talk about in the subscription agreement, we're asking for you guys to provide your the email addresses for your employees for electronic distribution purposes. So under ERISA, It requires that plan sponsors or their claims administrator distribute certain plan materials according to the Department of Labor guidelines. These disclosure guidelines apply to many of the documents that we've talked about, and many of them that you will see in the checklist. You know, the SPDs, the plan documents, the SMMs, the summary annual reports, COBRA notices, the SARs. I mean, just a myriad of things can be distributed electronically if done appropriately. So under ERISA, a plan sponsor can communicate electronically with folks. The rules automatically extend to employees that we know have access to the right technology. For employees that don't have access to electronic information as a part of their job, we have to go through the process of getting consent from them. I would venture to guess that most of the folks we're talking about here fall under that automatic rule, which is awesome. And then, you know, there's obviously a third set of individuals that kind of fall outside of that where we need consent, you know, whether it's, you know, dependents, you know, ex-spouses, COBRA participants, things like that. But going forward, it's the intent of the trust to distribute as much as possibly in an electronic format to plan participants, which is why the subscription agreement is asking for email addresses. Jay, I think I talked so fast that I got through it in under our time. So I don't know if we want to open it up for questions, if you want to elaborate on any of the topics. I will leave that up to you, sir.
Yeah, I think we should open it up to questions. Yeah, on as far as the electronic distribution and having emails, I will elaborate just a little bit about that before we open up for questions. You know, it's with the security requirements that banks are under, plus the need to be able to communicate. It's, you know, bankers relate to this, you know, they're under extremely tight security from a regulatory standpoint, while group health plans are under tight security as far as, you know, HIPAA is concerned, and you know, not being able to send covered entities such as advanced health plans not be able to send unencrypted emails that contain you know, personal health information. I mean, you take all these things into combination, and it's kind of become a heck of a job to communicate with folks outside of just, you know, calling on the telephone. And so, in addition to the regulatory requirements of, you know, providing, you know, documents to employees, you know, as far as like plan documents and different notices, we're also kind of finding an issue with, you know, some of the outreach that we're trying to do for cost containment, like, you know, the new SCRIPTA benefit, where, you know, they look for opportunities to save the participants and the plan money on their prescriptions, and they send out their cost savings reports. One of the vehicles that they're able to do that with is via email, or even in some situations texts. It's something that's kind of an ongoing discussion that we want to have with the banks as far as what's the best way to communicate with your participants. So, you know, if there's something that you feel like we could do better or differently to be able to directly communicate with the participants, we would certainly love to hear about that. You could reach out to you know, any of your reps that are there visiting your bank, Garrett or Brad or Melissa, or you can always just, you know, send something to customerservice@kemptongroup.com. But anyway, I just wanted to kind of put a little bit more on that topic. But I think we ought to go ahead and open it up to questions for a little while, since we are about 30 minutes early. I think that's the benefit of not, you know, I think we swerved into that, even though it was by accident, not being able to share your screen and your slides. Video, I think it got you to be a little quicker. So can you at least see the question interface, Cori?
Yes.
Okay, good deal. So we did have some folks that were requesting slides, and then we also have this question. I'll go ahead and read it out loud for the benefit of everybody, and then you can field that. We don't have 75% of our eligible full-time employees covered on the plan. Is this going to be a problem going forward? It is closer to 58% or 66%, depending on if we account our one director who is covered. So, you know, I think there's a couple of ways to look at that in Cori, and we kind of gave the straight, 75% of eligible, but you might want to talk a little bit, Cori, about some of the ways that the trust looks at things that move people out of the eligible category, like other coverage and things like that, for the purposes of determining the 75%. You want to address that?
Well, from a historical perspective, Jay, I don't know as if I can. I'm pulling up the provision here to see if I can get a little more meat to the topic for the question.
Yeah, so it was really, you know, if the individual had other coverage, you know, through an employer, through the military, through an Indian card, things of that nature, if they were documented to be covered somewhere else, some other group type of program, then they were kind of moved outside of the count of eligible.
Yeah, here we go. Yeah.
So we've been reviewing so many documents. I'm pretty sure that I did review that, so it's definitely still in there. So I'm glad you found it.
Yeah, so there's, you know, I talked about, you know, 10 words that are in a 2-paragraph provision. So I'm going to elaborate here for you. And then obviously when you get the subscription agreement, you may have other questions. So the provision states that the participating employer agrees that it will provide coverage under the group health plan it selects to at least 75% of its eligible employees. The participating employer shall provide such information as is required by the plan administrator to substantiate the adequate coverage. The trust understands that some eligible employees may decline coverage because they are covered elsewhere. Therefore, to determine if the 75% requirement has been satisfied, any eligible employee who declines to be covered under this plan because he or she is enrolled under a group health plan will be considered as covered under this plan for purposes of the 75% criteria. Let me see if I need to go any further. An eligible employee who declines to be covered under his or her spouse's plan, enrolled in a tribal plan, government plan, military, personally, and we kind of elaborate on what the options would be. They will be considered covered under this plan to determine if the 75% has been met. So I think that would answer their question, Jay. If not, hopefully they'll shoot you back a question. And just so you know, on my screen, when I do the drop down of the questions, I can see the platform, but I did not see that question. So I cannot see the questions that have been posed.
No problem. Yeah, so if that did not answer your question, yeah, please reach out. You can just reach out to us as soon as possible, and we would like to come and talk to your individual bank and hopefully be able to work something out on that. So
yeah, and I'll elaborate a little bit, Jay, and maybe you want to do the same for the purpose of this provision. And this is not unique to AHPT, but the health, the financial health of a MEWA is dependent upon the volume of the people involved in the MEWA, right? So you know, I've had people come to me over the years and we'd like to start a MEWA, and you know, we've got 30 people across the state of Illinois that want to participate, and you know, that's just not going to work. So the more numbers we have to spread the risk, the healthier our MEWA would be. And so that's kind of the rationale behind a provision such as this, and it's not unique to the trust.
Yeah, you bet. So the next question is, what is the stop loss limit amount that Milliman picks up? I'm assuming that the question is regarding the trust, what's protecting the trust from catastrophic claims as opposed to individual out-of-pocket maximum. So the stop loss level that the trust carries to protect the trust fund from individual catastrophic type claims is $275,000. So the trust is responsible for the first $275,000 worth of claims on any one covered individual. So that's a covered a member, so belly button, so employee, spouse, or dependent. Of course, you know, if somebody is in excess of that in a calendar year's time, the particular participant has no idea that is occurring, really, nor does the bank. So it happens kind of behind the scenes, and that reinsurance level, that specific reinsurance level or deductible, is something that is looked at by the plan administrator, by the Kempton Group. And it is also looked at, and there's input provided by Milliman, which is the actuarial firm, and then also by BKD. BKD also, accounting firm, also kind of looks into that for reasonableness. And over the years, it has ticked up. It's always just a balance between the premium that it costs, which is a fixed cost for the trust, versus the risk that is imposed upon the trust. So again, there's various methods for determining what is the correct balance between fixed cost and risk, and that's been determined at 275. I think it was been there for a couple of years, and based on everything that we're looking at now, it probably will stay at 275 into 2021.
So I'd like to just add on to that a little bit, Jay, and apply it to my MIWA that was for my dental clients. So in the example that I gave you, let's say that we had $400,000 in claims that we submitted to a stop loss carrier if there was a $275,000 specific deductible. It's not that the issue is not just that the stop loss carrier wouldn't reimburse us our 125. The issue is that it would be impermissible and against numerous laws for the plan to pay any of the 400. So in that case, we had to go back to the providers that had claims paid because this individual was not eligible. So I just so that everybody knows, it's not that situation where you have people that are covered that should not be. It's not just a stop loss issue, it's also a plan issue. Self-funded health plans are not allowed to pay claims for people that are not eligible. So in that situation, it wasn't a $125,000 issue because of stop loss. It was a $400,000 issue because the member was not eligible at all.
Yeah, that's a great point. That is a great point, Cori. You're absolutely correct. Okay, so the next question. We do require coverage, which they have with their spouse. Okay, so this is an adjunct to the other question about the participation. Yeah, so I think we're in good shape there. I think if Reagan is monitoring this, I think we need to go ahead and follow up with that particular bank and just kind of touch base with you. So we'll be back in touch with you and talk about that. So I think we're in good shape. Yeah, so good question. Okay, perfect. All right, is there any, I think we're out of questions on the list. If anybody else has any, we've certainly got some more time. So let's give it a couple of minutes. This is where we ad lib and talk about the weather, yeah. Cori.
Well, actually, I'm going to talk about you for a second. So as I mentioned in my introduction, I have MIWA clients across the country, and they all use different third-party administrators to administer their claims. They all use different stop loss carriers. You know, they have different vendors in their mix. And so I get to see kind of the performance of the various vendors across the country as it pertains to MEWAs. Now, a MEWA is a different breed than just a regular single employer self-funded health plan. You know, those I've got lots of those as well, but MEWAs are definitely a bit different breed. I have been involved with MEWAs across the country that had to dissolve because, you know, in some instances they just weren't managed properly. In some instances they you know, whether or not the actuarial analysis wasn't performed appropriately, or the PPOs that they were involved with, you know, weren't the best decisions to make. But I've been involved with at least 3 dissolutions of MEWAs, and I have one going on right now, actually. And I just want to say, and Jay's not paying me to say this by no means, you guys are in good hands. I don't have any other MEWA across the country that is managed the way that yours is, between your trustees and your plan administrator and the folks at Kempton. I really don't have any other MEWA to compare it to. You know, as my other MEWAs come up for renewal and are going out for RFIs and RFQs, I definitely you know, will be recommending Kempton for the administration of those plans, because the attention to detail and the amount of work and that goes into this trust is unlike any other trust that I have anywhere. So kudos to you, Mr. Kempton, and your staff.
I reflect that back on our team, and then also the bankers that really run the program that we rely on. That's the trustees. They put in a lot of time to stay involved, and they hold us accountable, and it's been a very good relationship for many decades. And so we certainly don't ever lose sight of who we work for. So thank you, Cori. I don't think we have any other questions. So I'm going to take that as kind of a cue that that everything that needs to be said was said. So we do have one follow-up, but then after that, I think this has been good. Please, you know, be on the lookout for some of the documents that Cori alluded to. Also want to give Cori some kudos as well. She has really given a fresh and very thorough perspective and inspection of how things have been run within the trust, and you know, certainly don't want to be disrespectful to you know, counsel before, but I think it's always good to have kind of fresh eyes on things, and Cori has certainly pointed things out that she believed needed to be done in a different way, and we've certainly immediately complied and gotten things exactly where she believes that they need to be, and I think I would echo the trustees' sentiment as well, that they've learned a lot in Cori's short amount of time with the trust, and we certainly look forward to you know, a long future. I might also add that, you know, if there are any bankers, HR or senior management that have issues related to advanced health plans in your bank that you'd like to speak with Cori about, you can certainly reach out to us and we can get you in touch with Cori. It's, you know, it's part of, as long as it has to do with Advantage Health Plans Trust, it is actually part of the trust engagement. So, you know, I would stop first off at Kempton, see if we can't field the question, and if we're not able to, we can certainly arrange to get a time together where you can speak directly with Cori. So anyway, with all that being said, I hope everybody is staying safe and warm. The ice storm, especially in Oklahoma, has been pretty tough, probably also the panhandle of Texas. And for a few of our members in New Mexico, I know it's been tough. So everybody hang in there, stay safe, don't get COVID. And I think we'll just bring the webinar to an end. Anything that you'd like to say in closing, Cori?
No, I thank you for having me today. And wish I could have seen everybody or been together, but under the circumstances, I'm just glad to have participated, and to the extent anybody needs anything from me or I can answer any questions, don't hesitate.
There will be another opportunity, and we'll make sure that we get your camera polished up for your photo op.
Thank you.
Thank you all very much, and enjoy the rest of your week. Bye-bye.